Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today we're talking about the Interlake Tribal Council of Manitoba. Cases that should have gone to the Supreme Court of Canada, but didn't. The province of Manitoba had a winter road that they wanted to convert to an all-season road. The purpose of the conversion was to allow more access to a First Nations reserve that was at the end of the road. The First Nations, when they heard about these plans, objected. They said that they had not been consulted or considered in determining whether or not to upgrade the road to an all-season road, and that the work that Manitoba was intending to do would impact upon their hunting, their fishing, their traditional rights and activities on the land. Manitoba disagreed and said that they had adequately consulted and notified the First Nation of what they intended to do. The First Nation applied to court for an injunction, preventing any further work on the road until the duty to consult the First Nation had been adequately judicially reviewed in court and a determination made about whether adequate consultation had taken place prior to commencing the work. The court agreed, granted the injunction, and prevented the province of Manitoba from engaging in any further work on the all-season road until the judicial review was resolved. Unfortunately, the province of Manitoba appealed and was successful at the Court of Appeal in overturning the injunction, finding that the court did not apply the correct test in determining whether or not to grant injunctive relief. And the core issue in the case came down to how the balance of convenience factored in when dealing with Indigenous issues, and whether or not the balance of convenience in determining whether or not injunctive relief is appropriate required special consideration when the individuals impacted or potentially affected by the absence of an injunction were Indigenous individuals, whether there was special consideration required for Indigenous groups seeking to apply for injunctions in those circumstances as a result of their Indigenous status. The trial judge had said, yes, that is a consideration that goes to the balance of convenience. If you strip away somebody's rights and culture and their ability to participate fully with their land, the balance of convenience favors saving that for a period of time until the duty to consult has been adequately adjudicated in court. But the Court of Appeal found that it was really more of the strict legal boring balance of convenience test. And unfortunately, the Supreme Court of Canada denied leave to hear the case. But this was obviously an important issue because as Manitoba and now Canada and British Columbia have all passed legislation to implement the United Nations Declaration on the Rights of the Indigenous People, then it's necessary to consider, particularly at every stage of an application in court, whether or not somebody's Indigenous heritage changes the lens through which the scope of the law is looked at. And there is a need to consider Indigenous traditions and history and culture at every stage of a court application involving an Indigenous person or an Indigenous nation. And unfortunately, the Supreme Court of Canada didn't really take this opportunity to have its first chance to weigh in on how UNDRIP and the implementation of UNDRIP in Canada has an impact on the rights of Indigenous peoples in dealing with their day-to-day activities and the work that provinces are undertaking in their traditional territories. It was unfortunate to see the Supreme Court of Canada fail to take this opportunity to adjudicate something that we know is going to be coming to them and coming to them and coming to them and coming to them over the coming years. It's an opportunity for the Supreme Court of Canada to get ahead of a significant legal issue that is undoubtedly going to tie up a ton of court time for probably the next 50 to 100 years in Canada. And yet they missed the boat. Hopefully another case comes before the Supreme Court of Canada soon so that we can have clarity now, rather than clarity after all sorts of works and construction has taken place that affects the rights of Indigenous people and negatively impacts their ability to work on their traditional territory. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.